Good evening, everybody, and welcome to the launch of Miller's Marine War Risks. It's rather odd to be launching a book in this fashion. We don't have any physical books to show off, and we can't even offer you a drink to celebrate with. But these are unusual times, and I suspect that a virtual book launch is probably very low on the list of odd occurrences for 2020. So instead, we're going to be talking about some aspects of marine war risks. And each of the authors will say something about a different topic for about 10 minutes each. And then at the end, we will have a single joint question and answer session. Now, if you'd like to suggest a question, you can post it in the chat. To moderate our Q&A session, we are honoured to have Sir Bernard Rix here. Sir Bernard will need no introduction to you. As a distinguished former judge of the Commercial Court and Court of Appeal, he's contributed a great deal to many areas of the law, including a number of war risks insurance cases, ranging from seizure to piracy. Sir Bernard also very kindly wrote the foreword to the book, for which all the authors are very grateful. And we're very glad that he's able to be here today at this virtual launch. And so without further ado, I will hand over to Sir Bernard to get things underway.
Thank you, Michael. Good evening, everyone. Since this is a book launch, I have provided myself with a celebratory drink, nicely coloured, Campari and orange, and the odd crisp or two. I hope it doesn't make too much noise on the site. It's a great pleasure for me to be here. It was a great pleasure for me to have written a foreword for this excellent work, now in its 5th edition. Written by our 3 distinguished speakers this evening, authors and speakers. We have a leading commercial silk, a leading academic, and a leading commercial junior. The silk and the academic are brothers. And the junior, I had the great pleasure of being helped by when I went to the federal court in Memphis as a special master or an expert on English law. Anyway, our 3 speakers and 3 authors are Michael Davey, our silk, who has been in a great number of the leading shipping and insurance cases, including the Ocean Victory in the Supreme Court. And amongst the nice things which people have said about him, I have particularly liked the remark that he is quietly persuasive, and you suddenly find yourself agreeing with him. He's also been complimented on his superb judgment. Our leading academic, James Davey, Professor of Insurance and Commercial Law, now at the University of Southampton, which of course is famous for its commercial law teaching. James has not only written extensively on all aspects of commercial law, and particularly insurance law, but he assisted the Law Commission on its revision of insurance law leading up to the 2012 and 2015 Act. And he has also given evidence to Parliament and the FCA on the likely effect of big data on insurance and inclusion of autonomous vehicles within statutory motor insurance regime. And most helpfully, as an academic, he is much concerned not only with the theory of the law, but also with giving policy advice. And he's a deputy president of BILA. And Oliver Caplin, our leading junior, now without a beard, so that you won't recognize him from his CV, has in his short time at the bar been in a very great number of very interesting commercial cases. And there again, I particularly liked some of the remarks made about him on legal sites. He's commended for his total unflappability, which is excellent, in the courts. And we're told that the judges are all charmed by him. So that is just how to be an advocate. And now Michael is going to start with the first of the three topics. Michael.
Thank you, Sir Bernard, for that. I'm going to be talking about the Brillantes Virtuoso. But first of all, I need to say a few words about the late Michael Miller, the author of the first three editions, and now honoured in the title to the fourth edition, which is called Miller's Marine War Risks. I had the pleasure of meeting Michael and his wife when we first agreed to write this edition, many more years ago now than I would like to admit. Meeting him in person certainly explains the style in which he wrote, as he simply loved to tell a good story. He had plenty of stories to tell, and he was quite the raconteur. That's very apparent in the first three editions of this book, which set out the cases in his inimitable style. It was very charming and entertaining. And although I'm apparently quietly persuasive, I don't think I can stretch to charming and entertaining. And so, although we've retained parts of his writing in his book, as was his wish, we've been a little bit more austere than he might have been, and provide far too many plot spoilers, I suspect, for his taste. But that brings me on to the Brillantes Virtuoso, a case which Michael Miller would very much have enjoyed, a story of fake pirates, according to the findings of the judge. The casualty took place in July 2011 in the Gulf of Aden, just within Yemeni waters, on a voyage from Ukraine to China. Judge found that a group of armed men who boarded the vessel, purporting to be a security team, were in fact part of a conspiracy to scuttle it. Once on board, they behaved as if they were pirates. They ordered the vessel to Somalia. The next day, there were gunshots, and a device was exploded on board, causing a fire. According to the judge, when the fire began to die down, local salvors helped to get it going again, a rather unusual role for a salvage team. Ultimately, the vessel was a CTL. Claims were brought by the owners and by the mortgagee bank on a war risks policy. The owner's claim was struck out for failing to provide disclosure, but the mortgagee bank, as a co-insured, continued its claim. It argued that it was unaffected by any willful misconduct on the part of the owner, and that it was entitled to recover as a co-assured. There are a number of potentially important points dealt with in the judgment by Mr. Justice Tier, such as a warranty to comply with best management practice. In other words, guidance as to precautions for transiting piracy areas. And his judgment may in the future be of importance in other cases, but what I want to touch on briefly is just the perils insured, which were put forward by the bank as applying on the facts of the case. So the facts in summary were that the vessel was rendered a CTL by the deliberate actions of persons engaged by the owners to destroy the vessel. Now, assuming that those persons and the owners were to be treated effectively as third parties, so far as the bank was concerned, what was the insured peril? Well, the first put forward was piracy, but it's difficult to see how that could have worked. They were fake pirates, certainly, but one has to do more than dress as a pirate and act as a pirate in order to be a pirate. So that really didn't stand much chance. The same is true for capture and seizure. This was a situation where at all times the vessel was still fully under the control of the owners. So difficult to see how that could have worked. And so that leaves persons acting maliciously or vandalism or sabotage. Now, it wasn't very long ago, before the B Atlantic reached the Supreme Court, that there was a broad test for malicious persons, effectively covering damage caused deliberately or recklessly. Now, ordinarily, one would not expect that deliberate damage by the owner himself would be covered. But there's no reason why not, provided the owner himself is prevented from recovering on the basis of willful misconduct. After all, so far as the bank is concerned, it doesn't really matter who does the damage. And so the bank certainly would have had a far stronger case on the old understanding of the law, a test developed by Mr. Justice Coleman in a couple of cases, that really simply only required deliberate or reckless damage in order to have the casualty covered. But now, after the B Atlantic, something far more stringent and narrow is required, a requirement of spite or ill will. And it seems that the Brillantes Virtuoso is a clear example of a situation where the judgment in the B Atlantic has considerably narrowed the scope of cover. So after the B Atlantic, we've got a requirement of spite or ill will towards the owner or the property itself. It's a little bit difficult to understand how you can bear ill will towards property. Perhaps the recent destruction of statues is an example, though. Although perhaps even there, it's not the physical statue itself that invokes ill will. Perhaps it's what the statue represents. And another aspect in which the law remains unclear is the suggestion that there cannot be a motive of personal gain, that somehow personal gain is inconsistent with ill will. Suggestions to that effect were made in the Salem, and Lord Mance expressed some concern about whether that was fully right. It's difficult to see why there cannot be ill will and personal gain. If, for example, a competitor destroyed the vessel of a rival, one can see both ill will and personal gain sitting together. So it seems that we still don't have a very satisfactory understanding of this peril, even though we have got a pretty recent Supreme Court decision. So what about vandalism and sabotage? Again, it's difficult to see that this was vandalism. It wasn't damage done merely for the sake of it. But surely sabotage seems more promising. Surely setting a vessel on fire in order to destroy it counts as sabotage. One can sabotage one's own property. An example of that would be to stop it being used by somebody else. If it is going to fall into the wrong hands, one could sabotage one's own property to prevent somebody else using it. But the judge construed sabotage as being limited to something which frustrated the purposes of the owner. And the purpose of the owner, of course, was to scuttle the vessel on the findings of the judge. And so it wasn't sabotaging his purposes, and therefore the bank lost. Now, this seems a little bit narrow, and it's really a common difficulty with these types of perils is that there is damage which is deliberate or reckless, and yet cover depends on proof of a particular purpose or mental state of the perpetrators. In many cases, one will know who they are and what they are up to. But in other cases where they evade detection and are untraced, it may well be very difficult. And so maybe there was something in the old pre-Atlantic definition of malicious persons, a broad test which would cover a number of these events without requiring the insured to have to prove precisely what it was that the perpetrators were up to. And so I suspect that we've not had the last word on these perils. And perhaps those of you who have suggestions for how it may be improved and answers to all these tricky questions, you can post those in the chat and we can debate those when we have some time at the end of the talk. So thank you for that brief introduction to the Brillantes Virtuoso. I will now hand over to Professor Davey.
Thank you, Michael. Okay, so I thought it might be interesting to consider the extent to which war risks present special issues in terms of the statutory principles that apply to marine insurance policies more widely. So I have in mind two of the, I think, kind of major statutory principles, the what we might once have called the duty of disclosure, now the duty of fair presentation, so the flow of information before the contract is made, and what we might historically have thought of as being a warranty, so the way in which insureds are compelled to behave in particular ways if they wish to remain insured. Since the last edition, both of these areas I think have changed substantially. Particularly because of statutory intervention. So the Insurance Act 2015, which covers commercial risks, has made substantial changes to both of these areas. So I thought it'd be interesting to review some of those cases. So in terms of non-disclosure, fair presentation, I'd start with the good luck. And this was a case, a war risks policy in which an explosive device was placed against the hull. And before any discussion as to whether or not there was cover, the insurer sought to defend the claim on the basis that it hadn't been told as to allegations made against the insured that were live at the time that the risk was placed in the market. And the issues were litigated, both initially in the High Court and then in the Court of Appeal. And I was struck by the expert evidence which was given to the High Court in that case, in which the expert for the insured said, well, we don't really worry about the character of the insured, the moral hazard issue in war risks. It's not really a factor in the market. One, well, there's never been a war risk scuttle. Now, that might have been true in 2005, but as we've just heard, that's almost certainly no longer true. Certainly not what the High Court found in the BV. The other issue that the underwriter raised was the kind of derivative nature of war risks cover. So they said, look, the hull and machinery underwriter is the person that really thinks about whether or not this is the kind of insured that we want to contract with. And as war risk underwriters, we just assume that that's all been considered there. So we don't really need any evidence as to the character of the insured when we're placing the war risk cover. Now, as one might expect, the underwriters expert had a rather different view and said, no, this is, if there is dishonesty, then all underwriters would want to know whatever the nature of the market. And the court was persuaded by that latter view, that actually the duty to disclose allegations of dishonesty arose just as much in a war risks context as it would in a P&I or hull machinery policy. But there is something about war risks cover that was being suggested here, that war risk cover is about what third parties do, about pirates or terrorists or strikers, that it's much less about risks that are in the control of the insured. And so you need perhaps to know less about the insured. I wonder whether that's changed. Certainly the 2015 Act sought to make the process of underwriting a slower one. This was at least the vision of the Law Commission, that it would be more considered, less kind of snap decisions and based on more evidence. So even if that was the case, I suspect the approach in the 2015 Act is to try and nudge the courts away from that, and markets too. The other thing that Mr. Justice Coleman said that I think might be important for us going forwards at first instance was the nature of the market. He described the war risks market as being low premium, high turnover business. So it was the kind of market in which the underwriter would not spend any amount of time investigating the risk, even if contentious information was put before it. The judge was persuaded that they would simply say, no, thank you. I'm not going to spend time on this. There's not enough money to be made by a detailed consideration of the insured's position. If it looks in any way a difficult risk, then we'll simply pass on and look for other vessels to cover. And that might well be important for us going forwards, because the Insurance Act 2015 has replaced the standard remedy if the insured fails to make full disclosure of avoidance of the policy, with now a wide range of different kinds of sanction, one of which is avoidance, if the insured wouldn't have written the policy, but it may also be that the insured is only able to claim a percentage of the cover, a proportionate share of the cover agreed, or indeed it may be that the policy is enforced with additional contract terms. Given Mr. Justice Coleman's description of the market as one where the normal practice was to make a fairly quick decision, and if anything doesn't look right, to simply refuse to insure, this would mean, I think, that we would expect in a war risk situation much more readily for the courts to say, well, the remedy of avoidance persists. The normal practice in the market would have been for the underwriter simply to have denied cover if they had been given the full information. And so avoidance will remain in some way the default remedy in this market, although perhaps not in all. The other way in which perhaps war risk policies might be thought of as different, because they're about the actions of third parties, is the way in which insureds are kind of compelled to keep the risk within a kind of an acceptable level. So we've always had the navigation clauses that have said that insureds must control where their vessels travel in the world. There are high risk areas that they must stay out of. And if they navigate towards those areas, then cover can be put at risk. Now, the navigation clauses are extraordinarily, I think, complex. Actually, if you read them carefully, the interaction of the held covered elements, you can be insured providing you agree further cover and pay an additional premium, with the duties on the insured to give notice that they either are or are about to be in breach of these clauses. I think provide quite a fertile place, certainly for teaching, but also potentially for litigation, other than they hardly ever seem to reach the courts. So the held covered clauses have really not been litigated in recent years. But the navigation clauses I think if we were to see something tested under the Insurance Act 2015, I think the application of Section 11 of the new Act to the navigation clauses would be really genuinely interesting and complex. I think that means lucrative for practicing lawyers and interesting for academics. But generally, I think there is a situation here where the 2015 Act, we might well see, if we see a war risks case, I think we might see some novel points of law being raised on the basis of the 2015. And I think on that basis, I will hold off from further conversation, and I'll pass over to Ollie, who will be dealing with cyber risks.
Thank you very much, James. I'd just like to add my welcome to everyone and thank you all for logging in to this virtual book launch. As Michael said, it is a shame we can't have a glass of wine afterwards all together, but I'm sure there'll be time for that in the future. I just wanted to also thank Sir Bernard for giving up his time today and to write the foreword. I know how busy he is. And then actually to thank also my co-authors, Michael and James. They're both, of course, infinitely more experienced and more knowledgeable than me in all things insurance. So as the most junior member of the writing team, it really has been great to learn from them over the last few years as we've written the book together. So on to the substance of what I want to talk about, cyber risks. One of the first things that attracted me to this area of law is the way that many of the war risks cases, especially those concerning the application of the insured perils that are covered in the first part of the book, have such an interesting historical or political factual context to them. And the case law in which the definitions of, for example, war, civil war, revolution, rebellion, insurrection, and the others have been explored reads like a potted history of global and local conflict for well over 100 years. And the question I want to think about for the next 5 to 10 minutes is how war risks insurance, including the case law on these insured perils, will be able to adapt and flex with the advent of cyber risks, something that the reported marine war risk cases have yet to grapple with at all. So English law is pretty clear, perhaps taking a slightly less strict view, a slightly less strict approach than in the US, that for the war peril to be engaged, there needs to be a real sense of sovereignty behind the belligerents in a conflict between, or possibly on behalf of, sovereign states rather than individual actors. In times gone by, it wasn't always probably very difficult to ascertain whether this was the case or not. If the armies of two states were locked in battle, one can see how the point would be relatively straightforward. But complexities in this area have arisen in recent years as the nature of international conflicts has changed from the battles of World War II to sharper, smaller skirmishes and the advent of proxy wars across the globe. Certainly in a cyber attack context, one can't quite imagine the tech forces of two countries engaged in an overt battle in the way that wars were previously fought. Fairly recently, there's been some obiter consideration by the Court of Appeal in this country, in IF P&C Insurance and Silver Sea Cruises, about whether the World Trade Center attacks were an act of war. Sir Bernard thought they might be, noting that this phrase, act of war, was potentially wider than just the peril of war. But Lord Justice Ward didn't think that act of war, that the World Trade Center attacks was an act of war, and he thought they were a terrorist attack. More of this was obiter. And Lord Justice Ward also went on to consider whether the war on terror, so-called, was actually a war or not, and he thought probably not, it's just a colloquialism. But one can see how the definition of the perils, or the learning around them, has needed to adapt and flex over time as the nature of conflicts has evolved. Cyber risks and attacks arguably present a very different and new type of situation. The very nature of a cyber attack, let's say the release of a computer virus or some piece of malware, will make it potentially very difficult to attribute responsibility to a particular sovereign state, and will probably also make it difficult to know whether a particular attack is clearly being targeted at another nation state itself, compared to perhaps just commercial interests of various states that might happen to be affiliated to a particular state, or damage has just spilled over onto an insured's assets when it wasn't even the intended target of the attack. Think perhaps of a virus or piece of malicious code that's transmitted beyond the original intended recipients, and how easy that is to happen. When one remembers that the war peril, as all of them do, need to be understood as commercial men and women would understand the phrase, and not as a public international lawyer would, it's perhaps difficult to imagine a war as we all may think of one, being fought through cyber means, in which both sides are trading easily identifiable cyber attack blows rather than using bombs and artillery, as was the case in the past. In the United States, Zurich in 2019 denied cover in relation to a $100 million insurance claim by Mondelez arising from the NotPetya attack, on the basis that that attack was an act of war. The NotPetya malware attack, thought by the UK and US authorities to be attributable to Russian state-sponsored hackers. And a claim by Merck, the pharma company, for $1.75 billion, again in the United States under its property insurance policies, again in the aftermath of NotPetya, was similarly rejected by its insurers, again under an act of war exclusion present in those policies. And to the best of my knowledge, those cases are still working their way through the US court systems. It may be a while before we see a cyber war actually falling within the war peril as it is interpreted today under English law, but a case raising the issue is sure to be around the corner for our courts too, just as these cases seem to be getting off the ground in the United States. And what of perhaps a rebellion? In order to fall within the definition of this peril, one has to show that there's been an attempt to supplant the existing rulers, or at least to deprive them of authority over part of their territory. Previously, one might have seen in the cases a militia being got together, going to the newspapers, the palace, or the military barracks in the capital city or other power centre, and trying to take control away from the government. And that's perhaps the Hollywood image of something like a rebellion taking hold. And something not too far from that was at the crux of a fairly recent case on insurrection, often considered in the cases alongside rebellion and revolution perils. That case is Grell, Tarrell and Caribbean Home Insurance from around 2004, in which a militia had stormed the police headquarters in the port of Spain, attacked the Parliament chamber and the city's television house, and it was held in that case that amounted to an insurrection. But thinking specifically of rebellion and the requirement to take control away from the government, in one sense it's quite easy to see how a rebellion may be established using physical force, but what of a situation where a rebellion might be instigated using cyber means instead of physical violence, perhaps using those cyber means to interrupt a country's computer systems or the systems and services of a region within a country? Could you have a cyber attack amounting to a rebellion which had the effect of usurping the authority of a government over part of their territory through locking that government out of its usual way of administering that region? What if the attack was just focused on a country's ports? It all sounds perhaps a bit futuristic, but as the world changes, I'm persuaded myself that we will see situations like this occur in the next decade, or something like it. Stepping away from the insured perils, one also needs to consider the various exclusion clauses that exist relating to cyber attacks and war risks policies. Imagine the hypothetical situation of a state-sponsored computer virus deployed against the shipping capabilities of another state or states. Perhaps, for example, one designed to infect and disrupt certain vessels transiting the Strait of Hormuz. Perhaps a virus that affects the navigation capabilities of these vessels, or interferes with the central computer system that allows a master and her crew to control the vessel. Does cover in principle extend to such a situation under the standard war risks policies? Well, as ever, it depends on the policy. For example, cover provided by the Hellenic War Risks Association to its members ostensibly excludes cover for losses caused by the use as a means of inflicting harm of any computer virus. However, that exclusion only applies once claims that would otherwise be excluded by the exclusion exceed $150 million across Hellenic's membership in any 1 year. Now, whether that exclusion is going to bite is difficult to assess. On the one hand, 150 million is a lot of money, and it would take quite some virus to cause loss of that amount to Hellenic's members in 1 year, one might think. If all the virus does, let's say, is cause delays to the transiting of the strait whilst navigational systems are reset or computer programs are patched. But what if the effect of the virus interfering with navigational systems was to cause a number of collisions or groundings and a series of CTLs? Very quickly, the losses could get up to the exclusion level. On the other hand, going to the Institute clauses, clause 1.1 of the Institute's cyber attack exclusion clause, CL 380, contains a wide-ranging exclusion, excluding cover for loss, damage, liability, or expense directly or indirectly caused by or contributed by or arising from the use or operation as a means for inflicting harm of any computer, computer system, computer software program, malicious code, computer virus or process, or any other electronic system. There's no stay of execution, as it were, over this exclusion, as there is in Hellenic's cover, i.e. there is no threshold like the 150 million threshold. So on the face of it, where CL 380 applies to the insured is in a potentially less advantageous position than perhaps one of Hellenic's members. The clause is also drafted very widely, covering loss and damage both directly caused by the occurrence of one of the named cyber risks, as well as damage indirectly caused by a computer virus or one of the risks. Interestingly, both types of cover provide protection from losses arising from the use of a computer system in the launch or guidance or firing of any weapon or missile. In the case of clause 380, specifically so by virtue of clause 1.2 of that clause, but only where that clause is endorsed on policies in covering the insured perils of war, civil war, etc. So it's damage caused by a cyber attack that's captured by these exclusions, not the conventional use of computers to effect a military strike. But these are just two variants of potential clauses that might exist in the market, although I would expect that they're the leading positions. So I hope that these thoughts provide an insight into what issues we may see coming before courts and tribunals in the next decade. I rather suspect that if I am sitting here in 10 years or so talking about the 5th edition of this book, I'll be speaking with reference to at least a handful of cases on this topic, and we'll have to wait and see if I'm right or not. But that's the end of what I want to say, and I'll hand over back to Sir Bernard. Thank you.
Unmute myself. Thank you very much to the three speakers and authors. Their 10-minute pieces has immediately reminded me of what an absolutely fascinating area of business and law insurance is, and war risks must be amongst the most interesting area of insurance. Of course, war is a terrible thing, but it does raise the most interesting problems. And I'm reminded how in my first year as a judge in the commercial court, I was absolutely walloped by two enormous cases coming right on top of one another, Kuwait Airways and Royal Boskalis. The second of those cases being, I think, amongst the most interesting cases that I've ever tried, and raised some really fascinating problems of evaluating evidence on a geopolitical level, but also a whole range of marine insurance issues. Anyway, let's get down to some questions and see what we've got. So, for instance, would war risk underwriters be wise to contract out of parts of the Insurance Act 2015? Go back to the Marine Insurance Act of 1906. That's an interesting question. What do the panelists think about that?
I think maybe I'll go first. I'd love to know what my co-authors think on this. I think it was quite clear that the Law Commission were acting under instruction when they decided to write essentially one set of rules for commercial risks, no matter what size. I think there was initially a view that it would be better to separate out the very high value risks that we might see in much of marine insurance and aviation and the like, but that government wouldn't support that. And the view expressed by the Law Commission was that they expected the high-end markets to simply contract out. generally speaking, although of course practice varies, it seems not to have happened, or at least not routinely and not across all markets. I think there are parts of the 2015 Act that look to be the kind of principles that you would apply to a small business or to a consumer. And I think the remedy for failing to provide sufficient information to fairly present the risk would be one of them. So I think Schedule 1. The substantive duty doesn't seem to change very much, really at all. But the remedies, I think, are likely to be very expensive to litigate where it's a very high value. So working out what the underwriter would have done had it had a proper broke seems to me to be potentially very expensive, simply in terms of the kind of evidence that you would need. So we have at the moment the inducement test that we're familiar with, but that's a threshold. You just have to show I would have done something different. But the new test requires you to show with a degree of precision precisely what you would have done differently. And I think that that's a real risk. The other one I think is Section 11. Section 11, which restricts the underwriter's right to deny liability on the basis of a breach of a policy term. I don't know what it means, and I've spent a lot of time trying to work out what it means. So I think that would be something certainly that I would seek to cross out.
Thank you. Anyone else like to join in on that question?
Well, personally, I think this is a good opportunity to start again and to perhaps have a different approach to how we deal with these issues, and whether it's wise or not for particular underwriters to contract out. I think it's important to actually make use of the greater flexibility. It may well be that it is slightly more expensive to litigate at the beginning, but once we have a number of cases under our belts and we can see how it works and what meaning is going to be put onto particular sections that nobody understands, then I think we'll be able to settle down to a regime that I think is much preferable. And so, although it may well be on particular cases, there are reasons to contract out. As in general, that's not something that I think would be very useful.
Oliver, anything to add?
Well, I'm not an insurer, so I can't easily put myself in the mindset of one, but I would have thought you probably don't want to be out on your own too much as an insurer. You're more likely to want to be part of a pack. And if you start, and the trouble with lots of disputes, of course, is always that you don't know what the dispute that will arise is when you're concluding your policies and you're tweaking these terms. And so you're attempting to try and predict the future without really knowing what situation you'll find yourself in. I think it's incredibly difficult. Certainly, as Michael said, until we've had a good number of cases go through the courts and we've built up a body of case law understanding how the Insurance Act 2015 is going to work in practice across its various parts. My instinct would be not to try and go it alone and create too much of a bespoke situation for yourself. But of course, particular insurers may think differently, but that's all I'd say.
I'm very interested to hear that insurers on the whole have not contracted out. As for the cost of proving what you would have done for the purposes of the new remedies under the 2015 Act, I'm not so certain how important a point that is, because I think that the real cost will be in keeping records, which will have to be done now under the new Act as a matter of course, as a matter of running an insurance business. And if you've got the records, then perhaps it wouldn't be too difficult to prove what you would have done. But that's just a hazarded view. I'm very pleased to hear from an expert on this subject like you, Professor James, that you don't understand Section 11 either. But there we are. Let's have another question. And here is one from Richard Hickey, which is particularly directed to Oliver, but not exclusively so. And he asks, how does the 150 million Hellenic gross limit work as between various members and assureds? On the basis of paid claims or received claims? Is this a recipe for a dispute? What do you think, Oliver?
That's a good question, and I'm afraid I don't know the answer for how it's calculated. Probably it's something that the underwriters over at Hellenic would be able to answer. But I agree that it could well lead to disputes depending on what basis they're using to put it together. But I'm afraid I just don't know the nuts and bolts of how it works. But what I think it goes to show is that there is a variety of clauses or approaches in the market, and it may not be that insureds currently appreciate that the level of protection they have in relation to cyber risks varies, and they may not even have considered the point because it's not really affected the shipping market yet in a significant way, in sort of major way, like the NotPetya or the WannaCry malware attacks, the WannaCry attack affecting the NHS a few years ago, and NotPetya affecting various other businesses. That hasn't really happened in the shipping industry yet. And so I suspect people haven't had cause to go back and look at their policies, but there are real variations to the level of cover. But it's a good question. I'll try and investigate it with people that I know over at Hellenic and see if I can get back to you after the webinar is over.
Any other contribution on that? I don't know how anyone dares to underwrite cyber risks when you think how widespread they are. I mean, most risks operate on specific cases and events and persons. Of course, war risk may operate more broadly. But cyber attacks can be so widespread in its consequences. I don't know how people dare to underwrite them, but there we are. And I suppose cyber risks might raise very interesting questions under one event clauses and such like, which are always interesting and always difficult. And even in the area of solicitors' negligence alone has led to 2 visits to the House of Lords and the Supreme Court in the last decade or two. Let's have another question. Are held covered clauses an ideal way of adjusting to fast-moving situations where the vessel is already en route? And is the old case law on them still a useful guide to current usage and legal effect? Who would like a go at that?
No, I think I'll have first swing again, if that's okay, and then I'll wait for Ollie and Michael again to tell me why I'm wrong. The job of an academic is to be interesting and wrong, I think, in this respect. So I think held cover clauses are extraordinarily interesting and remarkably under-examined both by the courts and by academics. There's hardly anything written on them other than a sort of slightly descriptive. I think they're fabulous because what they do is tell you how the parties should behave towards each other. I think they're really worrying if you would ever litigate them. But the point is, I think they're not there to be litigated. They're there to kind of set out a practice. This is what will happen when inevitably things have changed. So you are heading towards an area and a political event is taking place so that it may no longer be safe there. Or you've inadvertently strayed into an area which is a higher risk for the purposes of war risks cover. The idea that the parties set out in advance, well, this is how we're going to negotiate. And you may have to pay more money, or we may change the terms of cover, but it's all subject to mutual agreement. It's wonderful if it's setting out a process in which the parties then follow this and come to agreement. The difficulty is, it seems to be when you read the clauses, if you try and work out who is obliged to do what, and what happens if they don't do what they're obliged to do, that it's very difficult to track through and see clear duties. I think they're often thought to be a great protection to the insured. When I read them, I don't see them as a great protection to the insured. I think they're all really reliant on the underwriter agreeing to cover the extended risk. And it's just then about negotiating price.
Any other
Well,
contributors?
I do remember when we were doing the chapter on held covered clauses, that James and I think, didn't agree on anything, except that we didn't really know what was going on with the clauses or how they worked, either broadly or how the individual provisions were going to fit together. And it's extraordinary that, as James has said, they're not more widely litigated. I suspect it's because in practice there isn't a problem. One tends to find that clauses that are very badly drafted, if they create actual practical problems, get revised. Now, that may not be the case in insurance so much. Insurance, particularly war risks, is notorious for living for a very long time with appalling clauses. But in terms of held covered, it doesn't seem to have caused a problem. I suspect one day it will. But I mean, even in the context of the Brillantes Virtuoso, there were issues about held covered, and it was very difficult to see how the clauses worked. But at the end of the day, the particular clause wasn't the problem. The problem was that the reason why the vessel was calling at Aden was not the disclosed purpose. So that was the real problem. The fact that the underlying clauses were something of a mess didn't seem to get in the way of business being done. And if it had been something that was not nefarious, it seems that there wouldn't have been a problem, at least in practice.
I think this is very interesting indeed. I lecture at Queen Mary's at the Centre for Commercial Law Studies, both in London and Paris, on, amongst other things, on good faith, contrasting the common and the civil law. And of course, one of the things I teach my students is that except in insurance law, the common law doesn't have an overriding principle of good faith. Partly on the basis that everyone's worried about the uncertainties that would place our commercial law in. But it's existed for hundreds of years in insurance law, and although it has led to certain problems, in particular in the area of non-disclosure, it hasn't really led to a great deal of litigation under the specific heading of good faith in other areas. Although in the context of the held covered clause, you could well see how, if there were disputes, the doctrine of good faith might raise its head, good and proper. And you would find, in effect, that you would have questions of good faith in the negotiation of a contract, because it's a held covered situation, albeit you've got an underlying contract, which the English law has always been so worried about. So very, very interesting. But how interesting too, that in practice, these clauses have not raised a problem. And that's a very interesting contrast with what might well happen if it had to be litigated. All right, well, we've had another question, which is directed to me from John Russell. And I'm not sure that I ought to answer it, but let's raise it because it's been asked. So John Russell asks to say that it would be interesting to hear our views on whether the Brillante Atlantic was correctly decided. And I think the first thing I would ask before we pose that question for answering is whether it's subject to appeal. Do we know?
Well, the Atlantic's in the Supreme Court, so
It's currently in the Supreme Court.
no, it's been decided in the Supreme Court. So
Oh, it was decided in the Supreme Court.
yes, in 2018. So
It was your talk of Mr. Justice Cheer's judgment that confused me, but you're quite right.
yes, that's the Brillantes Virtuoso was the recent decision. The B Atlantic was 2018 in the Supreme Court. And so technically it doesn't matter whether it was correctly decided.
Well, it was correctly decided, wasn't it? If it's
another 100 years or so. And I think John Russell very cheekily wanted Sir Bernard's views on that, but he's probably just going to get my views, and he'll just have to make do with that. My view is yes, it was. I can understand, of course, why it was decided the way it was. If you use words like malicious and you put them in the context of things like terrorism and politically motivated attacks, then you are looking for something that requires some degree of ill will. And of course, the B Atlantic was a case where the last thing that the smugglers wanted was for any harm to come to the vessel, because that would have meant that their smuggling had been discovered and their entire purpose would have been frustrated. But of course, they were entirely reckless as to the use that they were making of the vessel. And I think that in the context of war risks, to give a broad meaning to malicious damage is something which is to be welcomed. If it is damage done to the vessel which is deliberate or reckless, it seems to me it doesn't really matter what the purpose was, whether it was terrorism, whether it was political, whether it was spite, whether it was just a wanton act of violence. It's the sort of thing that probably ought to be covered. And so I think that the test that was put forward by Mr. Justice Coleman in a couple of cases, the Grisha Express and the North Star, were very sensible and seemed to be workable. But then, of course, malicious damage, those are the particular words used. And if one wants to ask what's the mental state of those doing the damage that's required, then it seems obvious that something like spite or ill will is required. But I think it's a very complicated area, and I don't think we've really got to the bottom of what exactly this peril means. And I think all these difficult questions about what precisely the attacker intended and what was their motive is something that is, well, in my view, not a welcome development. And we'd be much better off with a broader test, which didn't seem to have been a problem. So that's my rather long answer. But none of it matters because it's the Supreme Court.
Chatting with the late lamented Lord Hobhouse one day on the question of dissent, he expressed the view that dissent in the Court of Appeal might be very useful, because the dissent might be upheld in the House of Lords, but that dissent in the House of Lords was completely useless because you were wrong. But I'm not sure that's right, because times change, and a dissent planted even in the Supreme Court may be a seed that grows a garden in later years, but there we are. I think that malicious damage is one of those phrases, or malicious, the epithet, is one of those epithets, like dishonest, which causes a problem as to what extent it requires an objective or only an objective test, and to what extent it may require a subjective element as well. And these words have always caused a problem for the law as to whether you look at these things entirely objectively or whether you look into the mind of the actor as well. That's my only comment on that. James, Oliver, do you want to have a go at bettering the Supreme Court? There's a challenge.
I certainly wouldn't want to go down that route, but since I've been talking about cyber risks so far today, I'll just link it back to that. In the clause 380 that I was talking about before, the Institute exclusion clause, there's a reference as part of that clause to a need for the cyber attack to be used in a way that inflicts harm. And that, I think, essentially is referring to this concept of maliciousness. And of course, in the Brillante case, nothing about the cyber risks was at any point in anyone's mind, but it represents quite a difficult or quite an interesting development for a cyber risk situation when you might have a lot of difficulty in identifying who actually perpetrated the cyber attack. You tend to have, sometimes people who are just being very disruptive, hackers, who may well have no intention of causing harm to the insured's property or even to property in general. They might just be trying to be disruptive, or they may be trying to, or let's think of an example where the malicious code or the virus is just meant to be monitoring a computer system rather than causing damage necessarily through the use of the code, and it just wants a door in for some sort of espionage reason or something like that. Would you have the requisite requirement there to engage the exclusion? Would the insurer be able to rely on it if you couldn't show that the intent was to cause damage? And I think it presents a difficulty.
Thank you very much. Well, I think that might be a moment to bring the Q&A session to an end. So what happens now? Do I hand back to anyone, or do I wish everyone salve vale?
I think it's the latter. Thank you very much for hosting this. It's been very good, and at some point in the future, maybe when we have some physical books and we're all allowed to gather together again, we can have a physical launch and share a drink together. And I very much look forward to that time, not just so we can have a proper launch, but so that we can all get together again. Thank you very much, everybody.
Thank you, Michael. I'll toast the authors. Well done. Nice to be with you.
Thank you very much.
Thank you very much, everyone. Thank you for logging in.
Thanks a lot.
Thank you.
Bye, everyone.
Bye.